Hello and welcome to this section on state registration of securities. In this section, we're going to review the various registration methods for securities with the State Securities Administrator. We're going to take a look at exempt securities, exempt issuers, and exempt transactions, and help you understand when a security may be required to register and when it is going to be exempt from registration. Now, when you sell securities within a state, those securities must be either registered, they must be exempt from registration, or they must be sold through an exempt transaction. If these conditions do not occur, a sale may not take place. So the securities must be registered, exempt from registration, or sold through an exempt transaction. Now let's take a look at how securities can be registered within the state. When a security is registered within the state, there are three different methods available: coordination, notice filing, and qualification. Coordination would only be used if the entity in question is an IPO. Coordination is only used when a company is first coming public and they have filed their S-1 registration statement with the SEC, and it's currently being reviewed by the SEC. So while the registration is pending with the SEC, they are going to register the securities in these states where they are looking to sell the securities at the same time. So they're coordinating their registration efforts at the federal level and at the state level. Now, a good indication that the issuer would use coordination would be if the words "file not yet effective." If they indicate to you in the question that the issuer's file is not yet effective with the SEC, that's an indication that the entity in question is registering an IPO and is coming public for the first time. If the entity is not going through an IPO, they may not use coordination. Now, it takes a minimum of 20 days for the registration to become effective at the federal level. And state registrations typically take between 10 and 20 days to become effective at the state level. However, you may never have a state level registration become effective prior to the federal level registration. Notice filing is traditionally used by investment companies, and they may use the term "an issuer who has a class of securities registered under the Investment Company Act of 1940. So perhaps Vanguard, Fidelity, Charles Schwab, any of the large mutual fund companies would notice file or provide notification to the State Securities Administrator whenever they came up with a new portfolio. Effectively, they are providing a notice to the State Securities Administrator, and they're paying a fee to the State Securities Administrator saying, "Hey, we came up with this new portfolio and we just wanted to notify you that we are indeed selling these shares of this portfolio to residents of your state." Now, qualification is traditionally used for smaller issuers. It would also be used for an intra-state offering sold under Rule 147. Securities that are sold only within one state must be registered with the State Securities Administrator within that state. Also, non-qualified issuers who are small issuers, perhaps their stock is trading on the OTC Bulletin Board or Pink OTC, would be required to register their shares in the states where they're going to be sold through qualification. This is literally hoop jumping. you are providing all of the information that the state securities administrator wants relating to the issue. They can require a specimen of the security. They can require updates on the progress of the sale. They can require the securities to be sold on a specific subscription form. They may require financial reports from the issuer. However, the state securities administrator may not require financial reports more frequently than the SEC does, which is quarterly. So these are the three methods by which securities could be registered or their sale could be given notice to the state securities administrator. It's coordination, IPOs only, file not effective with the SEC. Notice filing traditionally for those classes of issuers who have securities registered under the Investment Company Act of 1940. Those are management companies, UITs, and face amount companies or face amount certificates. And qualification for those smaller issuers or issuers selling securities within one state only. And here you provide all the information to the state securities administrator that is requested by the state securities administrator, and the registration will only become effective once that state securities administrator is satisfied with the submission. Now, certain issuers are exempt. The U.S. government makes the laws, and the first people they exempted from all these registration requirements were themselves. So all treasury notes, bills, bonds, etc., they're all exempt. They don't need to be registered in the states. All state and local governments within the United States are exempt from registration. So California is exempt, San Francisco is exempt, Colorado is exempt, Denver is exempt, Georgia is exempt, and Atlanta is exempt. You get the sense of what I'm speaking about here. All foreign national governments with whom we have diplomatic relations, all of their bonds would be exempt as well. Great Britain, Canada, France, all of their bonds can be sold to residents of our state without being registered. Now, Canada is the only foreign government that has provided an exemption at the federal level as well as at the state, local, or provincial level. So Canada's bonds are exempt, as are Ontario and Toronto's. This is the only foreign country given this exemption. Great Britain's bonds would be exempt, but London's would not be exempt because London is a municipality within the country of Great Britain. Now, we're going to talk about another type of exempt issuer, and those are banks, insurance companies, credit unions, savings and loans. Now, you have to remember that these rules and regulations were written in the 30s and 40s when most banks and insurance companies were not the type of banks we have today. The banks and insurance company were mutual style banks and mutual style insurance companies. A mutual style bank is one that is owned by the depositors. A mutual style insurance company is one that is owned by the policyholders. What we have today are bank holding companies or bank stock companies. Bank of America, their stock trades on the New York Stock Exchange. Bank of America is a bank stock company or a bank holding company. JP Morgan Chase is a stock or holding company. These are not what we're talking about when we talk about exempt issuers being banks. MetLife, Northwest Mutual, AXA, all of these are insurance holding companies. They're not mutual style insurance companies. They are not exempt. So if you just see the word bank and no word follows it, it's exempt. If you just see insurance company and no word follows it, it's exempt. If you see bank holding company or insurance holding company, it is not exempt, and they are required to register their securities. Now, once again, these rules were written in the 30s when our country was stuck in a deep recession. And in order to help certain industries grow and hopefully reignite our economy, they made certain types of entities exempt. The trucking companies, the railroads, the airlines, they are all exempt from registration. If you see the word consolidated, that means a consolidated carrier. That is a trucking, a railroad, or an airline. They are all exempt issuers. Probably the only way you may see it appear on your exam. So these are some of the exempt issuers you need to be familiar with for your test. Now let's take a look at certain securities which are exempt from registration. Certain short-term debt securities are exempt from registration because of the nature and quality of the issue. Commercial paper, remember, is short-term promissory notes sold by the largest, most creditworthy companies in America. Now, commercial paper needs to be sold in denominations of at least $50,000 or greater and have a maturity of no more than 270 days. So if they are sold in line with these guidelines, denominations of $50,000 or greater, and a maturity that does not exceed 270 days, the security is exempt from registration so long as the rating on this commercial paper is in the top 3 of the ratings agency's rating grade. Now, they could ask you a style question that says, an exemption from registration is partially based on the rating received on a promissory note, a debt instrument, a debt obligation. The credit rating received on these obligations is taken into consideration when determining whether or not these securities are exempt from registration at the state level. So make a note of that. An exemption from registration is partially based on the credit rating received on a promissory note or debt obligation. You might see that style question on your test. Now, securities that would otherwise be required to register may receive an exemption because of the type of transaction involved. Now, transactions with institutions are exempt. You can transact business with a financial institution in any security regardless of whether or not it is registered in the state because the transaction is exempt. The institution is a large, sophisticated investor and they can determine for themselves whether the investment is suitable or not. Transactions between issuers and underwriters are all exempt. They do not need to be registered because it's an issuer to underwriter transaction. It is exempt. An unsolicited order is also an exempt transaction. An unsolicited order is an order executed at the sole request of a customer. And let me see if I can kind of give you a scenario to help you understand this. Let's say a registered rep of a broker-dealer has a client who's a doctor. And the doctor calls up one day and says to the rep, I was reading a very interesting article in one of the medical journals about this little company that has a very interesting and promising new drug. I looked on the internet and I understand that they're publicly traded. And the doctor provides the rep with the name of the company, and the rep looks it up and says, yes, that's correct, they are traded. They're traded on the OTC bulletin board, and they are currently trading at $1.15 per share. The doctor says, you know what, I'm going to take a flyer on this because I think this drug is promising. Buy me 10,000 shares. The rep responds, you know, doc, this company has no revenue and almost no money. Further, the indication on my computer tells me that this security isn't even registered in your state and you probably shouldn't buy it. The doc says, thanks for the advice, but I'm going to take a flyer, buy me the 10,000 shares. That is perfectly okay because it is an unsolicited order, an order executed at the sole request of the customer. Now, a private placement is an offering of securities to accredited investors and higher. It is not made through a wide offering to the general public. No more than 10 non-accredited investors may receive offers in 12 months, and no commissions or consideration may be paid to registered persons for soliciting transactions in private placements to non-accredited investors. When a person purchases a private placement, they received unregistered restricted stock. The private placement wrapper protects the security from the registration process. And once that security has been purchased, the investor must agree to hold it fully paid for 6 months. And then if they are not affiliated with the issuer, they may freely sell it after 6 months. If not, they will be required to sell those securities under the terms and conditions of Rule 144, which we cover fully in the next section on issuing securities. So be on the lookout for 144. So private placements at the state level, no more than 10 non-accredited investors in 12 months, no more than 35 non-accredited investors in 12 months at the national level. I'll also throw out one more type of exempt transaction, and that is a non-issuer isolated transaction, or an isolated non-issuer transaction, one where the issuer of the securities is not involved in the trade. An isolated non-issuer transaction means one or very few per broker-dealer per year. There's no hard, fast rule for what the number is, but that is the definition of an isolated non-issuer transaction. Let's say we go back to our doctor and the rep says to the doc, you know, I know you're in this field and I was reading up about this company. It trades on the OTC bulletin board at $1.15 a share. I think it might be an interesting speculation for you, and you may want to consider buying a little bit just in case they come through with this drug. Well, the previous example was an unsolicited order. Here the registered representative is making a recommendation based on that security. That would be okay because it would be an isolated non-issuer transaction. The rep thought it would be an interesting speculation for one doctor client. That would be okay even though the security wasn't registered in that state. Now, I want to bring up a little test wording, kind of some games they play in the question. And what if an agent knowingly recommended an unregistered exempt security to a non-accredited investor? Would that be okay? Let me repeat it. A registered rep knowingly recommends an unregistered exempt security to a non-accredited investor. Would that be okay? Well, as soon as people say unregistered and recommends, they see recommends, and they see non-accredited investor, all sorts of red flags go off. However, the question says unregistered exempt security. All securities that are exempt by definition are unregistered because they are exempt from the registration process. This question, in a rather circuitous way, could be saying that the registered rep recommended a treasury bond or recommended a piece of commercial paper or a municipal security. This is what you need to be able to do to pass this test, is to identify what the question is asking you and make sure you read the question carefully so that you can identify the key. And the key in that scenario was that the security was exempt, so it was totally fine. Now let's take a look at federally covered exemptions for securities. Anytime you see the word federally covered, whatever comes next is not within the jurisdiction of the state securities administrator. And a federally covered exemption removes the item in question from the authority or jurisdiction of the state securities administrator. Securities that are given a federally covered exemption are any securities that are listed on an exchange. If their stock trades on the New York Stock Exchange or the NASDAQ, they do not need to register their common stock, their preferred stock, their bonds, their rights, their warrants, any securities they want to sell to state residents, because the SEC has provided them with a federally covered exemption that says if this company has met the listing requirements for an exchange, then they have to have certain financial credibility and their securities are suitable for purchasers in various states. So that is a federally covered exemption. A federally covered exemption is also given to investment companies. They remove the jurisdiction of the state securities administrator from investment company securities. The investment companies are not subject to the registration requirements of the state, and they would traditionally notice file and just pay a fee so that the state can get their fees. Now, these are some of the very, very state-specific securities registration concepts that you're going to need to be familiar with for your upcoming exam. In the following section on issuing securities, we go much further and much deeper into all the different types of offerings of securities you're going to need to know to pass your test. So let's move forward and take a look at the concepts we cover in our issuing securities video, and we'll see you there.